Welcome to Brief Encounters, the DC Bar Community's podcast channel. Today's episode is part of our Wellbeing Community series, which focuses on helping attorneys thrive, both professionally and personally. The legal profession is demanding by nature, but your well-being doesn't have to be at the price of your career. This series explores well-being and its impact on attorneys, sharing perspectives, tools, and conversations that support a healthier, more sustainable legal profession. Because when well-being is prioritized, you're better able to care for your clients and your work. Today, we're discussing occupational well-being, and our guest here today to offer perspective on burnout from the public interest lens is Professor Sandra Simkins. Sandra Simkins is a professor of law at Rutgers Law School and currently the Associate Dean for Clinical Education. Professor Simkins is the former director and co-founder of the Children's Justice Clinic, a direct representation clinic where she also focused on representing youth facing abusive conditions of confinement. Between 2012 and 2018, she was the due process monitor for the settlement agreement between the Juvenile Court of Shelby County, Tennessee, and the Department of Justice Civil Rights Division in its efforts to address constitutional violations against youth. Professor Simkins, it's so nice to have you here and to connect. Thank you for being here.
Thank you so much for asking. I'm happy to be here.
So to kick us off, tell us a little bit about your background and your work as it relates to attorney well-being.
The first time I heard about self-care, it was about 2003. I had been a public defender in Philly for about 10 years. And I remember a psychologist came in to train us because we were representing children. And she told us we were at risk for vicarious trauma and burnout because of our clients' trauma. And I remember this day so clearly because I wanted to make sure I didn't burn out. I had gone to law school to do public interest. I saw myself as a career defender. And at the training, the psychologist said there was a solution, and she handed us a list. She said if we did self-care, everything was going to be okay. And I took that list really seriously. I did all the things, the exercise, the yoga, the work-life balance, the strong network of friends, all of it. But fast forward 10 years, at this point, it was about 20 years of direct representation, and I knew that things weren't right, and the cases were getting to me more, and I knew I was starting to have the symptoms of burnout. But I'm a defender, and defenders are tough, right? And at this point, my whole world is juvenile justice. And so I decided to power through. I was going to do more yoga, took a longer vacation, got a shrink, all those things. But at the end of the day, it didn't work. I burned out anyway, and a few years later, I knew that I needed to make a radical change. My heart just couldn't keep absorbing this much pain. And I also knew I wasn't as effective in court. So I let go of the clinic and I let go of all of it, and I radically shifted gears. And in the aftermath of burnout, I felt two things. One, I felt enormous shame because I felt like somehow it was my fault that I had allowed burnout to happen to me. But then the other thing I felt was I was really pissed off because I felt like I tried to do everything right. I was extremely committed and self-care didn't work. And I wanted to know why. And that whole experience led me onto this path of doing more research and really beginning to think critically about the concept of self-care. And I'm really convinced that public interest lawyers need better tools.
Thank you for that. You've written that public interest attorneys need those better tools to protect their careers and that this concept of self-care is problematic. Can you talk a little bit about, I think, your perspective definitely shed some light on this from your own experience. Can you talk a little bit more about why the issue of self-care is problematic?
Yeah, so there's 4 reasons that I think self-care is so problematic. And number one, and far and away, if you remember nothing else, this is what I hope people take away, is that the problem with self-care is that by holding the individual responsible, we exonerate broken systems. And so when I was a public defender, we had a horizontal representation system. And that means one defender handled all the defender clients in a courtroom on a day. And it was typical to represent 20 clients a day, 2 to 3 days a week. And I am telling you, there is no way you can yoga yourself out of that kind of volume. It's just not possible. And when I understood that, everything lifted. But there are deep structural problems in our systems that lead to vicarious trauma and burnout. And I don't think individual solutions can fix that. The second reason is that I think that self-care is too vague to be helpful. Public interest is a really, really broad practice area. You can be doing direct representation in court, or you can be doing policy work in a public interest shop. And there are really different kinds of risks associated with different kinds of public interest work. The third reason self-care is problematic is because public interest organizations are not well equipped to support self-care for two reasons. One, there's enormous resource limitations. And two, there's this culture that really values toughness and pushing through. But the fourth reason is also that there's very limited data. And so this is really crazy when you think about it. We're all lawyers here, right? We are lawyers, right? Our job is to, require evidence and ask questions. But the legal profession has accepted self-care as the solution for burnout. And the truth is, there is very little evidence regarding the effectiveness of these strategies. Now, I'm not saying that meditation and exercise and gratitude journals, all that stuff isn't helpful. It's helpful in life, it's generally helpful. But in terms of saying that these self-care strategies can prevent burnout in these kinds of work environments, there is no evidence for that.
Thank you. And you've done some research in this area. We would love to hear a little bit more about what your research revealed and how this can help public interest attorneys.
Yeah, so what I found after analyzing all the empirical data that I could find, dozens and dozens of articles, is that there actually are personal and professional risk factors. And if you have these risk factors, your risk of vicarious trauma and burnout increases. And I'm going to just list them all, and then I can talk about each one a little bit. But the three personal factors that increase your risk of burnout is based on your gender, whether you have a prior personal history of trauma, and race. And the professional factors that increase the risk are if you work in a high stress, high touch practice area, whether you have a high volume of caseloads, whether you're a solo practitioner, or whether you're working in an unfair office. Okay, so those are the four professional factors. And then there's this other factor that has mixed evidence, and that's related to time. And if you want, I can talk about each one of those a little bit.
That would be fantastic. Yes, I'm sure all of our listeners would love to hear more about those. Yes.
Okay, so the first personal factor is gender. Women are at greater risk. They're at greater risk of vicarious trauma, burnout, and other mental health issues than men. Now, this is not surprising given how well documented gender bias is in the legal profession. But this factor is particularly important to this conversation because women choose public interest twice as often as men. And in some practice areas, it's overwhelmingly female. The second personal factor is having a prior history of trauma. And this is also a factor that's incredibly well documented. We know from adverse childhood experiences work and those kinds of studies that having prior trauma can impact mental health. But again, this is really relevant to public interest lawyers because often a history of prior trauma simultaneously draws lawyers toward public interest because we want to make a difference, and it makes them more vulnerable at the same time. And so it's critical that we're thinking about that as we're navigating our career paths. The third factor is race. This also is not surprising. Public interest lawyers of color are at a higher risk because they're likely to experience racism and discrimination by virtue of living in the United States. And the experience of racism can cause PTSD, racial trauma, race-based traumatic stress, and all of these can be precursors to burnout. And this, again, is an important factor because lawyers of color are more likely to choose and remain in public interest. So those are the personal factors. In terms of the professional factors, the first one is called a high stress, high touch practice area. All right. And there's this lawyer, his name was Ronald Tyler, and he was a public defender for 20 years. And he coined this term. And the concept here acknowledges the cost of doing direct contact human service work. It's the combination of being in a high stress environment like criminal law, plus having lots of contact with people. And so this is synonymous with direct representation and direct service work. But high stress, and this is where the articles were so fascinating to me, the empirical evidence has done a lot of studies and correlated higher stress, higher burnout for public defenders, criminal lawyers, human rights lawyers, asylum and immigration lawyers, people who work in the field of domestic violence, and people who work in child welfare systems. So those are big categories, but all of those categories are high stress and high touch. You have lots of clients, lots of volume. And no doubt this list is not exhaustive. I'm sure that if you're working with, unhoused individuals or veterans, you're also going to be in this category. The second professional factor we already mentioned a little bit is high volume. If you have a high volume caseload, that increases your risk. If you're a solo practitioner, that also increases your risk of burnout. And that's consistent with the growing evidence we have that social support is good for your psychological health. And the last professional factor is working in an office that you perceive as unfair. And so your office environment can really help you mitigate the impact of burnout, or it can make it worse. And like I said, the last factor is time, and there's mixed evidence on length of practice and time. There's some research that says, once you have some experience, you're better able to navigate burnout and deal with the challenges. But then there's also research that says the longer you're in a field, the more at risk you are. For example, there's this one study where they did a study of family court judges, and when they had been on the bench for over 7 years, they had greater risk.
Thank you for that information. One of the things that, you talk about is this notion that so much of this is structural, right? So since many necessary changes are needed to improve occupational well-being for attorneys from that structural lens, what advice would you have for organizations who are trying to address burnout from that vantage point?
Yeah, I think it's really challenging for organizations because with the financial limitations, some of the things that, if you had a lot of money, you could do would be to decrease your caseload or increase your staff, and those options aren't necessarily available. But what I do think that public interest organizations can think about is creating spaces for lawyers that are less intense, like spaces where you can rotate in and out of less intense assignments to get a break. When I worked at the public defender's office, there were particular spaces. Maybe it was a specialty court, maybe it was a policy liaison. I mean, these different categories of jobs where you're not dealing with clients who have so much trauma every day. You're not dealing with that high stress, high touch practice area in the same way. If organizations could create spaces for lawyers to access some downtime and take a break, from the intensity of some of the practice areas, I think that would be really helpful.
Thank you. And, you're aware that our bar in DC, we have so many mission driven folks that are doing this work, whether it be nonprofit, government sector, that sort of thing. I can imagine if someone's listening to this, I know, for myself, your story at the beginning was so compelling of saying, I want to continue to do this work. I don't want to burn out, right?
No.
And with the recognition that this is structural, this is how the system is built in so many ways. What can we sort of take away from an individual level about for someone who's trying to stay in it, for someone who's trying
Right.
to make this work? What can one do? Yeah.
Absolutely. I mean, I really think the most important thing every individual can do is understand your own risk factors, right? So I think about myself, for example, and I think back to my career. I had several risk factors. I was female. I spent 15 years in a very high volume practice, and I had a combined over 30 years of working in a high stress, high touch practice area. So there's three factors, risk factors that I had for a very long period of time. And that really puts everything in context. There was a reason I burnt out. I wasn't a loser who didn't do enough self-care. I was engaged in a practice area that carried a very high risk for a long period of time. I think if I had known about these risk factors, if somebody had said, yo, Sandra, you can't do this forever. You can't do direct representation and condition of confinement indefinitely. It's going to be too hard. Nobody said that to me. But had I known in hindsight, I would tell my younger self, you need a plan. You need a plan to do this. If you want to stay in the game for your whole career, think of ways that you can pivot and decrease some of your risk factors, right? So maybe I find a way to do appellate work, to do more policy work, to decrease some of the risk exposure that I had in that high stress, high touch practice area. I was able to decrease the volume. When I became a clinical professor, I really decreased the volume. I'm not in a high volume world anymore, but I was still doing all the direct representation. But I think if lawyers understand their risk factors and plan strategically, they will be more able to stay in the game as long as they choose to. But if they ignore the risk factors and just think that self-care is going to solve the problem, that's where I think they'll get into trouble.
Thank you. That's incredibly helpful and really tactical for someone listening. So thank you for that. Is there anything that we haven't talked about in our conversation so far that you want to make sure to share with our listeners before we close?
I think I mostly covered it. I would say understand your risk factors, protect yourself, and remember there's no real evidence that self-care works.
Thank you. Thank you for that and for your perspective today. Thank you for listening. If today's conversation resonated with you, we'd love to have you join us. The DC Bar Wellbeing Community is open to those who want to be part of building a healthier legal profession. Visit the DC Bar website to learn more and to become a member. And there's always something happening, from live programs to on-demand resources. DC Bar Communities offers a wide range of well-being activities to meet you where you are. Head to the DC Bar website for a full list of upcoming and on-demand programs. If you enjoyed this episode, please like and subscribe to Brief Encounters, and be sure to check out Toward Wellbeing, the DC Bar's Lawyer Assistance Program podcast channel, for even more conversations dedicated to your well-being. Join us tomorrow as we discuss the second pillar of lawyer well-being, the emotional pillar. Take care of yourselves. We'll see you next time.